And the big legal news this week, a federal judge ruling that Google has illegally held a monopoly in internet search and text advertising. Google vowing to appeal that ruling. Joining us right now is a man who opened the case into Google, former Assistant Attorney General Makan Delrahim, led the DOJ's Antitrust Division. He's now a partner at Latham and Watkins, and there is so much to talk to you about, Makan. How are you?
Good morning, Andrew. Thanks for having me on. It's good to see you again.
I want to talk broadly just about what we're seeing in the antitrust world, because there's a whole number of cases making news. The Google case, as we mentioned, is something you started, and I just wanted to get your reaction to where things stand right now.
Well, the judge, ruled this week, and I think it's going to be interesting to watch the process. The next step will be remedies, and I would anticipate Google to be appealing this case. It will take at least a few more years before we see the end of this.
When it comes to remedies, and I think you and I have talked about this before, do you think a remedy is more likely to be behavioral, meaning there's going to be some watchdog over the company, or do you think it would be structural, as in breaking up pieces of it?
There's some tough precedents for structural remedies, mainly the Microsoft decision at the D.C. Circuit, where Judge Jackson had actually ordered a breakup of Microsoft, and the Court of Appeals reversed that unanimously. So I think it's going to be tough. But the Supreme Court gives a lot of discretion to the district court judge. 2 years ago, the NCAA decision, Justice Gorsuch's opinion, lays out some of the groundwork and gives a lot of discretion. So it'll be interesting to see what evidence they put forward and how they could justify whatever remedy actually addresses the harm that they found. So it is going to be, I think, from an academic standpoint, this is going to be fascinating to watch.
I have a broader question for you, which is, and I made this point yesterday, you can disagree with it, which is, are cases like this fighting yesterday's war or yesterday's challenges, if you will? And the reason I mention this is all of a sudden, here we are in 2024, and it very well may be that the search world, the blue link economy, is going to get upended by the OpenAI economy. All of a sudden, we're talking about whether Bing and Microsoft, which is partnered obviously through OpenAI to become something again. Whether we think that Perplexity or some of these new competitors are going to emerge.
You're absolutely right. I mean, that's something that we thought a lot about at the Justice Department when I was there. What is the right solution? I don't think the right solution is really some of the wholesale proposals to change the antitrust laws. I don't think that's the solution. We have to take a look at the process and the procedures, especially in these dynamic markets. 20 years ago, a lot of folks were worried about, Microsoft. Do they have there's a whole new set of technology companies like Google and Facebook and others that came about, and antitrust should not have interfered with what Microsoft was doing. A unanimous D.C. Circuit disagreed with that. But the question becomes, if there was harm that was found, how long did that go on? And is the current legal system responding to that? I'm not a fan of the regulatory system like you have in Europe, but there could be tinkering in the judicial process that could make it a lot more efficient.
Makan, we were mentioning this other case that was brought just yesterday by Elon Musk's X against advertisers. It's an unusual case because it effectively says, you don't want to advertise on my service, so I'm suing you because you've all ganged up on me. What do you think of that?
I have not read the complaint, to be completely honest with you, but these types, some of the hearings, the information that came out of the hearings, they raised some questions. Whether or not they become antitrust problems, we'll all have to wait and see. This reminds me a little bit of what Justice Brandeis said, a number of years ago about, some of the impact on First Amendment that they have. But whether or not it really turns into an antitrust case, we're all going to be watching and seeing how the case develops. It's also a lot like some of the antitrust reactions to the ESG efforts. When you have group activity that is meant to do good, but the Supreme Court has continued to remind us that competition is the answer, not collusion, and the ends do not justify the means by how you get there.